So the next order of the day is commencement of debate on the general principles of a bill for an act to make provisions to cover the lacuna in the event of death of a governorship candidate anytime before the conclusion of an election. A bill for an act to amend the Electoral Act of 2010 to empower election tribunals and courts to declare candidates who scored the second highest votes as winners of elections when the tribunal or court holds that the winner of the election is unqualified for the election ab initio. A bill for an act to ensure that all political parties are gender sensitive and eliminate all forms of discrimination in all political parties. A bill for an act to include the use of card readers as part of the act and clearly specify the tenure of office of the Secretary, Independent National Electoral Commission. Bill for an act to increase the amounts permitted as maximum election expenses to be incurred by candidates standing for elections, and a bill for an act on nullification of election by tribunals or courts and for other matters related thereto. Honorable members will recall that the four bills were consolidated on Tuesday, 26th April 2016. Now invite Honorable Femi Gbajabiamila to move that the bill be now read a second time.
Standing for elections and a bill for an act on nullification of election by tribunals or courts and for other related matters. Mr. Speaker, I so move.
Yagba Federal Constituency. I second the motion that the bill be read for the second time.
Bill, I believe, that goes to the very heart of our democracy and the instrument upon which our democratic process depends, and that is the Electoral Act. I will address a couple of the issues that are contained in the bill herein, and thereafter give an opportunity for the other sponsors to address the issues in their bill. Mr. Speaker, the first part of the bill is a bill for an act to make provisions to cover the lacuna in the event of death of a governorship candidate. Mr. Speaker, we all living witness to the fact that the elections in Kogi threw up a scenario that perhaps was never envisaged by the drafters of the Electoral Act. A scenario where, upon the conclusion, more or less, of an election, the governorship candidate that perhaps was the front runner and for all intents and purposes should have been declared the winner of that election, drops dead. A scenario which I don't believe has ever happened in Nigeria, or for that matter, any part of the democratic world. And because, as legislators, we cannot envisage every possible scenario until those very unusual scenarios come up or occur, it is incumbent upon us to plug those holes as and when they arise. That is the dynamism of legislative work. And it's for that reason that I feel and I believe that this bill is very important. Yes, it is an unusual situation, but it's not impossible for it to occur again, God forbid. Some may argue that it is like being struck by lightning twice. A very unlikely situation, that you'll even be struck by lightning once and die. But again, it is not impossible. And for that reason, this bill seeks to plug that lacuna, to allow for the deputy governorship candidate in an election that has more or less been concluded short of declaration, to automatically take over the office or the position that the governorship candidate was in prior to his death. Mr. Speaker, I personally believe, like many of our colleagues, there really isn't a lacuna. I believe when you look at them, when you interpret the Constitution and the Electoral Act together, that situation, you can argue, was already taken care of. But unfortunately, perhaps there is some ambiguity. And it's that ambiguity that this bill seeks to address. The second part of the bill, Mr. Speaker, is to allow for the use of card readers by law in the Electoral Act. Prior to now and the last election, we will all attest to the fact that nationally and globally, the use of card readers was acclaimed. We had perhaps the fairest election in history. And the singular reason was the use and introduction of the card reader. Mr. Speaker, unfortunately, the courts, perhaps even rightly, have insisted that the card reader was a mere policy or regulation, in-house regulation of the electoral umpire, INEC, and that it is not embedded in our electoral laws. And for that reason, the courts, in several tribunal cases, or rather, not even tribunal, right all the way to the Supreme Court, did not recognize it as law. Again, we have been faced with a challenge where we have seen the use of a system that has sanitized our electoral process. But unfortunately, the Supreme Court in its wisdom has said that is not part of the law, and they would not enforce something that is just a policy of the Commission. It is for this reason, Mr. Speaker, that this part of our law has now been amended by this amendment bill. And what it really says, if I may read, Mr. Speaker, is that accreditation, not voting, accreditation shall be with the use of electronic card readers, and any person not electronically accredited by the electronic card reader shall not be eligible to vote. And then it goes further to say, provided that where the electronic card reader malfunctions, an incident form shall be filled and such person shall be accredited manually and be allowed to vote. So what it has done, it has put paid to the argument that this is not in our laws. It has also taken care of situations that arose in the last election where perhaps a card reader malfunctioned. What it has done, what this House will be doing, is to obey or to follow what the guide the Supreme Court has given to codify what is already part of the process. It's already part of the process. But the Supreme Court has advised us to codify it and put it in law form, in statute form. And that is what these two portions of the amendment of the electoral law represent. Thank you, Mr. Speaker. Thank you, honorable colleagues.